Hello everyone, let's talk about bank accounts, life and death. We have part one that talks about what happens to the bank accounts during your lifetime, who has access, what can you do now. So be sure to watch that part one, even subscribe to our YouTube channel. There's a button or a link there below to receive notification of future videos. But today let's talk about death. What happens to bank accounts after death? Previously, we talked about joint tenancy, we talked about having a power of attorney, we talked about adding someone to your bank account with signatory powers, we talked about having a bank account in a trust, a business, and payable on death designations. So let's talk about, again, death. Let's talk about how you don't have the same options, of course, as you do during your lifetime. So let's start with joint tenancy. If you have a joint tenant on your bank account, if you have a co-owner, your spouse, sometimes your child, not a good idea. Watch our other educational videos on why that is. But if you have a joint tenant, usually, if that's what the bank account rules, your paperwork says, if you have a joint tenant, when one person dies, one owner dies, the other one just gets it. So basically at that point, you go to the bank with the death certificate of the joint tenant and they take their name off the bank account, and you become the sole owner as the surviving joint tenant. If the deceased person has a power of attorney, the power of attorney terminates upon death. All power of attorneys or guardianship proceeding terminates upon the death of the person. So the power of attorney is no good. So don't try to go to the bank with a power of attorney for a deceased person because it will not work. Same with if you have someone added to your bank account as a signer, so not as an owner, but just with powers to write checks and help you pay bills and such, that usually also terminates upon the death of the person giving you that authority to sign on their behalf. So that's not going to work. So what happens to the bank account after death? Ideally, the owner of the bank account has a payable on death designation, a POD. Basically, it's a form. You walk in the bank and you say, I want to add a POD to my bank account, my spouse, my child, my 3 children, whatever the situation may be. You sign a form with the bank, and then when you pass, your beneficiary, your POD, goes in with your death certificate and they get a check. That's just the easiest way to ensure that someone will have access to those to those funds upon death. Please don't, when you consider putting a POD, please don't think that you're going to list your youngest or your oldest daughter and knowing that she'll pay for your funeral and pay debts and then share with her siblings, because it doesn't work that way. She just gets a check. She doesn't have to do anything. So that's a topic for a future video, but for now, just be aware that a payable on death designation, it's an easy way to transfer money upon your death without having to go through the court system. Let's say you have a bank account that's in the name of the trust, so the trust is the owner, then whomever your successor trustee is, they'll have the authority to access that bank account. So usually with a revocable trust, you are the initial trustee, and then within the trust you say, upon my death or incapacity, I designate so-and-so as my successor trustee. At the time of your death, your successor trustee will have to do an updated certification of trust, attaching your death certificate, telling the world they passed, and then they'll have access to those funds. And of course, those funds, if they are in the trust name, have to be used according to the terms of your trust. If the business is if you have a bank account that is titled in the name of a business, an LLC or corporation, the operating documents of that business dictates who has access. So be sure that your operating agreement, your bylaws specify that upon the death of the owner or a shareholder, this is what happens. This person will have access. This is what will happen to the money, how are to be used, and so on. Very quickly, before I'll let you go, if you don't have a payable on death designation, if you don't have the bank account in a trust, so basically, in theory, no one has access to that money, it can get complicated. If the bank account, all of your financial accounts without beneficiaries are under $50,000, again, this is Oklahoma law, they may be able to be collected with a small estate affidavit. If you have a bank account for over 50,000, let's say 60, 70, you just sold the house, you just inherited some money, then, and it doesn't have a POD, it doesn't have a beneficiary, it doesn't have a joint tenant, it's not in a trust, that bank account will have to be probated, meaning that your family will have to go through the court system to collect those money, because the bank is not going to know who to pay, and the bank is not going to ask around, were they married, how many kids did they have? They're going to say, you file for probate, I'll give the money to the courts, let the courts figure out who gets what. So that's how it works with bank accounts upon death. I hope this video helped. Once again, be sure to subscribe to our YouTube channel and send me an email if you have topics for future videos or if you have any questions. Thank you for watching.